fundamentally is important, which is now even reduced to 4 months with the last additional protocol, so it's even getting more stricter. The reason being that the court wants certainty and effectiveness. It wants to have things very quick, so you have to move really quick. The problem is threefold with the 6-month rule. When does it start, when does it end? And there is case law to that, which the court calculates beginning and end in a very pragmatic way. It begins as soon as you have knowledge or have a signed final decision by the state authorities, whatever that looks like. And it ends the moment you send the thing to Strasbourg into the postal stamp. So that's pretty straightforward. Problematic is continuous violations. The court was confronted with that in a Turkish case. In 2004, Ülke versus Turkey, and the problem was that a young man in Turkey was drafted to the military, and he was a conscientious objector. He didn't want to do military service. So the way it went is the young man was taken to the barracks and was given his arms, and he refused to take the weapon, and was then sent away and imprisoned for a short time or fined, I don't know exactly, without the possibility of a remedy. And then was taken back again to the barracks, and the play started again. So that went on and on and on. And the person wanted to complain, and the Turkish government said this person has never tried to exhaust any remedy. And the court said there is no remedy. So that is sort of what do you mean by the time limit. We don't care what the time limit is, because that's a continuing violation that goes on and on and on. So there are cases where the rule is being broken. Other than that, the court is indeed very strict for self-protection. And that in itself can be a question and an issue. With the 4-month rule, you have to be really, really quick now. And if you consider the damage done and the psychological trauma that you have suffered and the circumstances, 4 months is getting pretty quick. So should there perhaps be more space? Should there perhaps be a year? Or is the court on the right track to say that it should get ever more strict? Well, the Conforting introduced one admissibility criteria which is really problematic. A response to the many cases before the court was to say we only want to have the most important cases. Part of the response was to say the single judge procedure. We kick out clearly inadmissible cases as soon as we can. And where we have clearly established case law, we have a 3-judge committee that works quicker than a 7-judge chamber or 7-judge chamber. But Article 14 introduced another very interesting notion, and that is that where there is no significant disadvantage to be expected for the victim, the case should not be admissible. Now, if you think about that, that's a bit more problematic. Because what is no significant disadvantage to the victim? The way it is worded is the applicant has not suffered a significant disadvantage, unless there is some requirement for the significant disadvantage. And these elements are, 3 elements are usually used in a cumulative fashion, with only the first 2 being really important. One is the absence of significant disadvantage. When you present a case to the court, how do you know that your case has no significant disadvantage? For the victim, it would always have a significant disadvantage, because otherwise it wouldn't have come to the court, even if it's a minor thing. So this is not a very objective criteria. What the court said is that we're not looking at the victim or the victim's perception as a matter of principle. We're looking at a minimum level of severity. One is that it should include purely technical or formalistic issues. Just a matter of form should not be covered. But secondly, it should also mean that it should really have, and that is from the victim's perspective, a real significant disadvantage. That may or may not be measured in objective terms, that may or may be measured also with the idea of the perception of this violation. So you would look at the right involved and the seriousness. A right to life violation might always be significant. The right to privacy, somebody opens your letter and reads something which is not interesting anyway, might not be so significant. But perhaps it's just a perception of the applicant that this particular letter was important for his personal life. So you have also rather soft criteria. The court also uses the applicant's conduct. It's even more complicated. Yeah? Did the applicant submit the application in good faith? Or was it it just one of those letters that should actually have been non-admissible but were admissible and we want to get rid of it in some other way? So there is kind of some loose criteria that the court uses. The court has done that in some civil cases, less in criminal cases. So whenever there's criminal conviction, the court would say that's really significant. But in criminal cases, not necessarily debating on objective criteria. A Ukrainian case of 2011, Canino versus Ukraine, the lady was convicted to stole something that was worth less than €1 and was convicted and complained, and the court was prepared to say that both the conviction was so small and the theft was so small that that is not a human rights issue. On the other hand, she suffered consequences in her private life and lost her job. So that from a victim's perspective, that was actually a significant disadvantage regardless of the money involved. Another case was against France quite recently, 2013, Aon versus France, quite an interesting one. So that person was given a fine of €30 for a fantastic crime, insulting the French president. So the idea was, well, that is not significant. A crime of €30 for insulting the French president is not really a big deal. You pay it and then you say, what is it? The court said, no. We want to examine this case because we think that has something to do with European public order. Is it acceptable in Europe to be criminally fined for insulting the highest person in the state? To which the court answered, no, it's not. Yeah? So there is no royal prerogative of not being insulted. So neither the €13 nor the more or less non-existing consequences for the victim, he paid the money and went away, it was done on the spot really, was sufficient for the court to say, we see that there is severity not for the victim, we see the nature, but severity for European public order. We want to have this clarified what that is. And similarly to that, slightly overlapping, the court is prepared to look at it when the respect for human rights does require looking at it on the merits, that is to clarify states' obligation in a more specific way, particularly in cases of continuous cross violations. So to say again what the court has probably already said before, that means identifying structural deficiencies and adding to emerging case law. Roloff versus the Ukraine was a case where the court order was not enforced. The whole thing was very minor, but the court said we want to look at it because this is again a non-enforcement of the court order in Ukraine, which we identify as a structural problem. We want to build up case law on that. We take it on board. And we accept that there is a significant disadvantage, not for the victim, but for the structure or for the setup of the Ukrainian legal order that has effects. It's similar to the Aon case versus France, versus Romania, 2012. She was fined €17 by the police for some minor crime. Paid it and went away, but then decided to lodge an application nevertheless, and the whole thing went to the court. And the court was tempted to say no significant disadvantage, but then because she claimed an Article 6 violation, that is fair trial, the court was so interested to find out whether a fair trial procedure can be applied to the searching on the spot by a policeman and the paying of a fine in regard to the specific situation of the legal system in Romania. And said we're taking it because we think there is an issue that may have an impact that goes well beyond that €17, and that we want to find out if there's a fair trial guarantee, if the executive power of the state acts, that was a particular problem with Romanian law, acts as if it were a court and provides that particular fine, not as a fine, but as a kind of court. So the court is also curious, it seems, in certain instances. The case was to be considered by a domestic court, lost its importance because that was then realized that's only admissibility anyways, that should be considered in the admissibility criteria. That was introduced to speed up proceedings. It didn't really work. It didn't work well because there were very few cases. And the amount that the court now has to invest, whether or not there's a significant disadvantage, was more of a time than it would have been just to take the case and say it's a well-established case law committee, free committee, and thank you very much. So the procedure was a very limited success in reducing the backlog. You had at the best times close to 100,000 decisions, 100,000 applications declared inadmissible, and in 40 the court gave the ground of non-significant disadvantage. So that's bad. That was really, but it was meant to allow the court to deal with it. Beneath that procedural thing in the stories is of course the question, well, could that really be a way out? That a human rights body says, in my understanding, you have not suffered enough damage. Or with every damage that you suffer, or that you perceive to suffer, under human rights terms, significant in the procedure. And it would be very different now, say, if you were in different positions, I would assume. But for pragmatic reasons, that may well be the case, that courts do not take all the cases, but just some cases, and have a certain discretion in taking or not taking these cases. Final point on a short break. Not substantially the same as a criteria.